Hi, this is Darin Mangum. I'm the host of the PPM Attorney Capital Forum. Thank you for joining us. We're doing session number 6. Apologies for those who attended live last time. We had some technical difficulties. The live session went well, but the recording didn't take. So I'm redoing this. Re-recording this session, so it's up on the platform, so available for your use. So if you've been looking for that, this should be up within a few days. So anyway, wanted to again thank everyone for attending. Again, whether you're attending live or if you're watching this on your own time. We are excited today. We're talking about PPM disclosures, what is required, okay? When it comes to providing disclosure to investors, this is where most people fall short when if they're not using a full disclosure private placement memorandum. Oftentimes they're going to get into trouble because they invariably are going to be faced with a situation where they have lacked. They haven't been able to provide enough material information to the investor. Well, and what does that mean, material information? And if you have the handout or the outline, we're going to talk mainly about materiality today. What does it mean what is material information? Because most of the time, a claim for securities fraud will turn on the question is the information that it was either disclosed or that was not disclosed, is it material information, material to making an investment decision? And the standard of materiality, and that's oftentimes the thing that is argued the most in securities fraud cases is like, okay, well, yeah, we didn't feel it was necessary to provide that information, or that information was not material, and the investor or the plaintiff, the company, that's what the company is saying, but the investor's counsel is always saying, no, this wasn't material information, and if they can convince the court of that or convince the jury of that, then obviously the securities fraud claim typically will stick, right? And so that's the whole importance of having a full disclosure or private placement memorandum when you're offering securities, because it covers all the various material topics that have been deemed by securities regulators and also by the courts to be, hey, this is material information that investors should know, even if they didn't ask for it or they didn't even know to ask for it, right? There's still information that is deemed material, okay? So these cases date back to 1976 and 1988, the cases of TSC Industries versus Northway in 1976, and then later on, about a decade later, the Supreme Court case of Basic versus Levinson. And both these cases turned on the question of materiality, and the Supreme Court basically says, hey, and in the context of securities fraud, is there a substantial likelihood that, and in the definition of material, if the information is deemed material, meaning that it needs to be disclosed, if an investor would consider it important in deciding how to vote, or if the fact that it's not disclosed would change what they call the total mix of information, right? So, for example, let's say there's a contract that is, maybe you have a license to a specific technology, and let's say, that contract is about to expire, right? And let's say it's within maybe a month of expiring, and there's no possibility to renew that contract. And let's say the company's entire business is predicated on that contract, okay? And an investor would probably need to know, instead of just saying, hey, yeah, we've got this contract, this license that allows us to do this. Oh, by the way, it expires a month from now, right? Okay, well, likely the investor would change its decision to invest if that investor really knew that contract was about to expire and that it was not likely to be renewed. Likely that investor would probably not invest, right? And so that would be an example of, hey, that little fact, it's not enough to say, oh yeah, we have this awesome contract in place that enables us to do X, Y, and Z. Oh, and by the way, it expires next month. Okay, that little thing, okay, that will sink the ship if that's not disclosed. Now you disclose it, you say, oh, by the way, it's not going to be renewed, and maybe the company is going to be able to continue under some way. Okay, well, hey, at least we disclosed it, right? And so now you can't come back later and say, hey, I didn't know. Well, it's in the PPM, right, that this is going to expire within a month. Now, obviously, if the company was going to have to fold, I mean, that'd be, even if you disclosed it, I mean, again, if it's like, okay, the company's going to go under if this contract expires. Okay, well then, even though they disclosed it, they probably shouldn't be taking the money, right? Because the company is basically going off a cliff. They're just asking for a lawsuit, right? So, but ordinarily, you'd say, hey, and maybe they may say, hey, look, the contract is going to expire. We maybe have some other options that we're going to be exploring to enable us to do the same thing, maybe with some other vendors, blah, 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 blah. Okay, well, now the company has a likelihood to have a longer longevity, right? And so, yeah, so that's just an example, right? And this other court case, again, Basic versus Levinson, it talks about, would that information be deemed by a reasonable investor as important in order to make an investment decision? And would it significantly alter the total mix of information, right? And you see this happen in cases where, okay, the fact that my brother-in-law works for the company, right? Okay, and let's say he's a highly qualified person, okay, and maybe, okay, well, shoot, I didn't disclose the fact that this is just an example. I didn't disclose the fact that my brother-in-law is my brother-in-law. I just had, he's on the payroll. Yeah, okay, that might be information that an investor might say, hey, wait a second, that's material information. It's a conflict of interest because he's your brother-in-law, works for the company, right? On the other hand, if it would not have affected a reasonable investor, let's say the guy is like Harvard Law School grad, he's highly qualified, highly competent. He basically is the brilliant brainiac behind the company, right? Okay, I didn't disclose he's my brother-in-law, but would that have changed your investment decision? Would a reasonable investor likely not have invested based on that one fact? Oh, he's your brother-in-law? No way, I'm not going to invest. I was like, wait a second. He's not some deadbeat relative that I've got on the payroll. No, he is the brainchild of the entire operation. He is, he's basically, you know what I'm saying? So investor, that investor would have a hard time. Just the fact that he's your brother-in-law and you didn't disclose it. A judge might say, you know what? I think you probably, a reasonable investor probably would have just gone ahead and invested anyway. And it may not be deemed material given it wouldn't really alter the total mix of information, right? It wouldn't really change the trajectory of the investment. A reasonable investor would be like, oh, okay, so he's your brother-in-law, so what? He's still, brainiac, right? If Elon Musk was my cousin, okay, I didn't disclose that, but okay, well, Elon Musk is running my company, or he's, helping provide resources, whatever. Likely investors wouldn't care, right? And so it goes to this reasonable investor. Would a reasonable investor deem it important? Okay, and so if the answer to that is yes, then you need to disclose it. If the answer is no, well, maybe you disclose it anyway, just to take some potential gasoline off the fire. Again, anything you can do in a PPM the disclosure wise to, take wind out of their sails or take fuel out of the fire. I mean, these are, analogies, but mixed metaphors, but you know what I'm saying? It would definitely help to, prevent any sort of future litigation, right? Or it may dissuade an investor from bringing an action because, in a lot of cases, sometimes plaintiffs' lawyers, they're going to bring the case anyway. But, if they look at all the disclosure and say, you know what, we're happy to take your money, but I don't think you're going to win. Are you going to really spend $100,000 to try to go after this $100,000 investment? Probably not, right? And so if a lot of times the level of disclosure, even plaintiffs' attorneys, even though they make money suing people, they're still going to probably talk their client out of it, saying, "Hey, look, I don't think this is not going to be a good case. I don't want to take this on. We don't want to take loser cases. We want to take slam dunks, that kind of thing, right?" So anyway, so that's really the standard. Okay, would a reasonable investor deem it important in making an investment decision? Okay, and sometimes that reasonable is made by, is it reasonable? Sometimes that's a decision made by a judge. Sometimes it's a decision made by a jury. The investors, they're going to put themselves in that situation, say, would I deem it to be material information? No. If the answer is no, if it doesn't really alter the total mix of information, it's not a game changer, so to speak, then likely the case is not going to move forward. Likely the case is going to get kicked out of court. Likely it's going to be dismissed. So anyway, but that's the standard, right? So and so anyway, so that's the criteria by which we determine materiality. Now, the last session we had we talked about a lot of the key elements of a PPM. The disclosures that are oftentimes included in a securities offering disclosure statement, whether it's a PPM, whether it's a prospectus or an offering statement, any kind of disclosure like that. Here we're just going to go through the various. The most common again, these are common elements in a PPM, but this is the information that definitely needs to be disclosed. That's going to be determined in material regardless, okay? And that is the following types of information. Number one is financial information, okay? And when I say financial information, I mean current financial information, which is different than a financial forecast or a financial projection or pro forma, right? Oftentimes I'll say, "Hey, client, send me your financial information," okay? And they'll send me a pro forma. And I'm like, no, we don't want a pro forma, because what is a pro forma? Pro forma is, rosy future projections. Hey, we're all going to make $1 million, $1 billion, whatever, okay? That doesn't really tell the investor where you currently stand, right? That's all, and it's totally fine to use a financial forecast in like a pitch deck or like just an investor presentation, but you would never ever. And I've seen sometimes securities attorneys, they'll just plug in a financial pro forma in the PPM, not really realizing that, wait a second, this is not really disclosing information of where the client or where the company currently stands from a financial point of view. It's all future blue sky forecast, right? So, so again, I'm telling you, never ever put your even if you have another securities attorney, not us. If they're plugging in a pro forma in your PPM, tell them no, you don't want to do that, because why? I mean, investors, if there's ever a litigation over the investment, they're going to do what? They're going to go off of the PPM and they're going to say, hey, these financial projections were misleading. they were overly stated. And the investor can say, well, I base my investment decision on these financials, on these pro forma, right? And which doesn't really help you at all, right? Because pro formas are always wrong. That's like the weather, trying to predict the weather. Even if they're wrong in a good way, if you understated the future performance, and you wound up overperforming, still they're going to be off, right? So I'm talking about, you need to provide what is the current balance sheet, what are your current debts and obligations, even if they look crappy, right? Even if you're losing money every month, at least you've disclosed it. Again, investors they never invest based upon where you're currently at. I mean, where you're currently at may dissuade them from investing, because it's like, holy crap, you're over your head over heels in debt, right? You got a couple $1 million in debt, with no cash flow. How is this gonna work, right? Well, at least you disclosed it, right? Now you can say, hey, here's the disclosure, here's where we're currently at, here's the PPM, but hey, here's a forecast based on what we think our future performance is going to be, blah, blah, blah. Obviously, you want to have a disclaimer in there saying, hey, this is a pro forma, this is a hypothetical. You want to have a disclaimer on any sort of financial forecast that you use that points them back to the PPM and say, hey, look, don't base your investment decision on this. Even as a practical matter, most investors do, right? You still want to make sure that from a legal standpoint that they have been apprised of all the current material information, which is what? The material information is, here's our balance sheet. We got $1 million in debt, and maybe it's all coming due next month, right? It is what it is, right? And so at least you've satisfied your obligation to disclose that. And then now you turn your attention to, hey, let me tell you, maybe paint you a picture of where we think we're going to go. And obviously with your investor capital coming in, then maybe we can get there, right? Maybe we can pay off this debt, or maybe we can refinance the debt, or whatever, whatever it is, right? So that's I think the most critical. And I've seen clients, they'll try to talk me out of it, like, oh, well, do we have to put the financial statements in there? Yes, you do, because it's going to be deemed material information. A reasonable investor, any judge, any juror is going to say, wouldn't you like to? I think it's important that you would want to look at the financial statements, because that may, a reasonable investor would do that, right? Even though a lot of them don't. A lot of them just sort of, okay, I never even looked at the financial statements. I never even asked for them. I just, was excited about the company, Well, if you had a PPM in there and they signed off that they received it, okay, well, they were disclosed that, right? Even though you didn't look at it, right? That's how that really plays out. So, financial information is materially important. So, the other category, business operations and strategy. I mean, this is really your kind of the meat and potatoes of your business plan. Again, we're not focused on the pro forma, and oftentimes, I'll ask for, hey, give me your business plan, and depending on who wrote the business plan, maybe the business plan is just overly optimistic and blowing smoke everywhere, just about everything under the sun, like, oh, we're the greatest thing in the world, we're the greatest, we're going to be the next Google, we're going to be the next Facebook, whatever. Well, and it's great to have, like, hey, here's our strat. But I'm talking about just pure mechanics. You don't have to like blow a lot of smoke to say, hey, look, here's our business plan. Here's why we think we're going to make money, and just state it factually, like, hey, this is our strategy, and this is maybe what we've been doing, and this is what we plan to do. Just state it very succinctly like that, right? Don't try to oversell it, right? But yeah, I mean, that is still material information. What is the objectives of the company? What are the your strategies, what have you? The next category is risk factors. I see that all the time. Clients are like, why do we have to put like 20 pages of risk factors in this document, right? Well, number one, I mean, again, the whole idea is to make sure that the investor is disclosed of the risk associated with the investment. A lot of times they don't realize all the risks that they're associated with an investment. They may say, "Oh, it's real estate, so it's got to be safe, right? It's tied to the ground." Well, that may be true, but there are a lot of risk associated with real estate. Whether it's financial, whether it's geographic, whether it's economic, whether it's whatever, right? And so you just want to make sure that's disclosed in the PPM. Again, they could skim over it, skip it, but hey, at least it's in there. And 9 times out of 10, it's not gonna really talk them out of it. But it's just, hey, look, you say, hey, look, by law, we have to disclose all the risk associated with this. You definitely need to have industry-specific disclosures in your PPM. Like if you're doing a cryptocurrency offering, or if you're doing an oil and gas deal, or you're doing a pharmaceutical company, right? Any one of these have very, very, very different risk profiles, very different risk factors that would go into that, and that's why we custom draft at our law firm. We custom draft each one to tailor it to the exact needs of that client or whatever their industry is, right? So you can't just throw in generic, although there are some generic, hey, you could lose money, this is not guaranteed, but a lot of times clients are trying to go it on their own. They're just like, oh, I'll just throw some blanket disclosures that I found off the internet and think they're okay. But you definitely want to drill down into the specifics, not just of the industry, but also of the company itself, right? What is the, are there other material fact or risk factors that may be very specific to this particular deal, right? It depends, right? If you're building high-rise condos in Florida, right, in a place where there's a lot of sinkholes, okay, just maybe general risk factors may not be enough, right? You want to maybe drill down to the very specific, industry, and also what are some specific risks to this particular venture that may need to be disclosed. Again, going back to the standard, would a reasonable person probably want to know this? Would you want to know this, right? I mean, again, most of the time you just got to put yourself in the investor's shoes and say, man, if I was putting my money in this, would I want to know this? I mean, if the answer is usually yes, right? I would probably want to know that, even though it may be uncomfortable. Oh, that doesn't really make us look that good. Well, you should disclose it, put in the PPM, and then at least you've disclosed it to the investor. They can't come back to you later and say, hey, you didn't tell me that. And also you could sleep with yourself at night, right? You could, have good conscience, right? And say, look, I there is risk in everything, right? So, hey, at least I told you about it, disclosed it. But hey, let's focus on the positives. Let's focus on that. But hey, the whole reason this PPM is here is just because look, don't use your your retirement fund for this because there is risk. Don't use your kid's college money for this, right? Because there is risk involved, right? You could lose it, right? I mean, at the end of the day, any investment should be approached that way, right? So, certain like also more material information is like legal risk, right? Regulatory matters. Are you a highly regulated industry, like we have clients are pharmaceutical companies, right? Are you is there maybe litigation that's ongoing regarding the company that may need to be disclosed, right? Or have you had any kind of securities infractions in the past, right? Those are all key things that are always going to be deemed material. Have one of the partners have a bankruptcy in the past, or so you have to look at that stuff too, right? And disclose it. Doesn't mean you have to draw a big red circle around it with stars around it, but no, you're gonna have at least a paragraph talking about, oh, my partner Joe here, he had a bankruptcy like a couple years ago, and hey, that's always deemed material because why? It's a financial thing, right? So it investor might want to know that, right? And maybe most of the times they don't, but maybe they would. So put it in there, right? So also, material information regarding the management and the key personnel, who's running the company, right? You want to definitely, sometimes I'll say, hey, look, client, we need a substantive bio on each of the executive officers of the company, and also any key personnel that are critical to the business. Okay, we need to put their bios in the PPM. That's super important, right? Because it doesn't they need to know that, hey, who are these people that are running the show, and what are their credentials, right? If they never went to college and they never went to they didn't graduate from high school, and they just have basic, that may be important to an investor, right? Investor might say, oh, you know what, this is a highly complex thing, and maybe again, maybe it's like, oh, maybe it's this engineering company, and oh shoot, the founder never graduated from engineering school, right? Okay, well, maybe I should know that, right? Maybe I should know that information. What is the background? Do they just graduate from high school yesterday? Are they just 18 years old and they've never done anything before? Okay, well, I would probably need to want to know that, right? And so as an investor, right? So, information on the key management, key personnel is always deemed material. Also material contracts. I touched on that a little while ago, earlier, and hey, is this, are certain contracts really critical to, to getting to getting the business off the ground? If you really need to, like I said, if you have this license that is super critical to the business, or hey, we're gonna have, the only way we're gonna be successful is if we get this government contract, or if there are certain things about an existing agreement that may be important, right? And the whole business oftentimes may turn on a specific contract, right? Or an agreement with a specific employee, right? Like Elon Musk, right? Like I always throw his name out, right? Because but he's like, oh, hey, is he gonna? He's the CEO right now, but he may leave, right? His contract expires next month. This is just an example, but okay. Well, if I'm an investor, I may want to know that, right? If I based all my investment decision on, hey, you got Elon Musk on your board of directors, or Warren Buffett, or whoever it is, and they're leaving, or they're expiring, they're okay, well, I would need to know whether that contract is in force still, or if it's expiring, or whatever. Again, that may not be the critical thing, but it may be deemed important to the investor, right? And a reasonable investor would likely, and that, again, going back to the Supreme Court case, would not disclosing that change the whole mix, or disclosing, would not disclosing that change the investor's mind, or affect the total mix of information being provided, right? That's really the standard. Again, we touched on litigation. Do you have, oh crap, we have got we've got all these investor lawsuits, right, pending currently. Okay, well, unfortunately, that would be something that you'd want to disclose. Oh, hey, we have these cases that are kind of currently pending. We may not think that they're going to have any merit, but they exist, right? Again, we talked about past, maybe it's past litigation about that may be material, right? And again, we also touched on industry-specific considerations as well, if you're following along the outline. Again, what are the consequences? Again, we've talked about this. Again, if you materially misstate the information, or you fail to put it in, and a judge agrees with either the SEC, or a state securities regulator, or a private plaintiff counsel that, we believe this is material information, then okay, you're looking at minimum, you're looking at civil civil penalties. You're looking at a disgorgement of the investment itself, different, and potential criminal liability if it's bad enough, right? If it's egregious enough, like if you were reckless in not disclosing the fact that you don't have the technology that you say you are. Okay, that's straight out fraud, right? That case regarding what was it called? What was the guy's name? Anyway, the founder of that Nikola. I forget his name, but anyway, he was the one making. What was his name? Anyway, he was the one that was. They were making these trucks that were running on hydrogen. These diesel trucks. Trevor. Anyway, I'm messing it up. But anyway, Trevor Ingman. No. Anyway, he's the company. They basically totally lying to investors. Like, look at these trucks rolling down the hill on hydrogen, and really it was just gravity pulling the truck down the hill. Just straight up. I don't care in that kind of situation. Okay, you could probably still disclose, hey, these trucks run on gravity and not on hydrogen. Okay, well, good luck. You're just basically lying to people. That's really not going to help you. Okay, yeah, guess what? You're going to go to jail, right, for that. Best practices we talk about. Again, engaging competent legal counsel. Hint, hint. You could certainly turn to our law firm, Mangum and Associates, or again, just the fact that I'm the partner of that firm and I'm hosting the forum here doesn't mean that you have to go. You're free to hire anybody you want to, but anyway, you want to hire a competent securities counsel to make sure those disclosures are accurate and also up to date, right? So that's important, right? So. Anyway, hopefully this is a good recap of the live session, and again, this is going to be recorded. We did have I did keep my notes from the we had some questions that were posed by a few of the participants, and again, if there's any topic around this subject or any other subject that you want to have covered, feel free to email us. You can email me at darin@mangumlaw.net. Or you can send us a message through the system, and you could we'll try to address that. If not directly through email, we could certainly pick it up on one of the next forum session. Anyway, but last time Tom had a question. He says, hey, I've got a partner who had a DUI, and he also had a bankruptcy. Do I need to disclose that? Okay, well. The DUI, the bankruptcy is a yes for sure because it's deemed to be, it's a financial matter, right? And the fact that you're dealing with people's money, it's important to disclose a bankruptcy in the PPM. The DUI, it could be deemed material if it's like recent, or if it's maybe a recurring thing, or let's say the CEO has 2 DUIs and one more. Some states have these 3 strike laws, right? I think Texas is one of them. I could be wrong. I don't practice in this space, but I know that hey, DUI. If you have so many DUIs, then it's like, okay, not only will you take your license away, but it's automatic jail time, or something to that effect, right? So, or maybe it was marijuana possession, right? Something like that, where there's strict guidelines on, hey, if you get caught one more time, then you're going to jail. Okay, well, the fact that the CEO of the company has something on his record from high school or from college where he got picked up on a DUI, and now it's like 30 years later. Okay, I would not disclose the DUI. It's not material. It's not going to change anything, right? On the other hand, if the DUI was last week, okay, okay, why would that may affect the investor's perception of the company, because why? It's recent, right? It's like, it's not something that happened way in the past, right? It's like, oh, well, the CEO that I'm about to give money to may have a drinking problem, right? Maybe, and also, okay, if something else happens, if this continues, then, maybe he might be out, incapacitated, or not able to function or run the company, So it really depends on would it affect the total mix of information? Obviously, a DUI from a long time ago, I'd say no, but if it happened recently, I would put it in. I would put it in the PPM, even though it's embarrassing. It's not, not something you're proud of, but, better safe than sorry, right? Put it in there, and then, okay, if the investor brings it up, maybe you can explain it. Maybe, hey, the legal limit in Utah was, point, I don't know, I don't know what it is, but it's like, oh, it's 0.05 and I was 0.06 and I was in town visiting, I didn't know, whatever. Okay, well, that explains it. At least I put it in the PPM, it's disclosed, and the investor got a chance to address it, and maybe you have a perfectly legitimate explanation for it, and that's fine. And then you're in the clear, right? You laid it out there. Investor is going to say, oh, okay, well, that's understandable, totally good. Okay, I'm going to invest anyway, right? And it's not going to be a big deal. Whereas if you had left it out and then later it comes out that, hey, wait a second, I didn't know he had this DUI, and blah blah blah, and now you got a problem. Janet said, I've got a contract with my CEO that is. What does she say here? Janet says, I've got a contract with my CEO that is about to expire, and I can't get him to renew. Is that material? I would say yes. That would be material, right? I mean, you could sort of soften it and say, hey, look, and again, you could have general language to say that, hey, look, we may have people coming and going. Key people that may, but let's say the CEO has brought a lot of their investors with them into the company, right? Okay, and the fact that he's leaving, okay, or potentially leaving, right? I don't know if it's a man or woman, but anyway, you know what I'm saying. If the fact that this contract, you might say, hey, look, here's our CEO, and then maybe in the material contracts you say, hey, we're trying to renegotiate our contract. In the event that we don't, we may have to find a replacement. Okay, well, that's fine too, right? You just say it out there. That way, people that invest based upon maybe the CEO's celebrity status, I won't use Elon Musk anymore, but they pick some really high power executive person that has a lot of charisma and blah blah blah. Okay, well, maybe is that going to hurt the company when he or she is no longer around? Maybe, and so best just to let people know that, hey, look, this person may not be around much longer, but we're obviously actively trying to find a replacement. So anyway, hopefully that makes sense, right? But again, all these are very specific. It's always easy. Okay, I err on the side of disclosing it, right? Because again, most of the time it's very easy to explain. Investors appreciate it, right? And obviously, if your value proposition is strong enough, then it's not going to make a difference. It's like, look, we think we got this great new invention. Whether Janet is running the company or Tom, okay, well, we still, as long as we have competent people, I think we'll still be okay, right? So anyway, those are some specific questions that people had. I think we also cover some case studies, some examples, right, of different material, how that plays out. And so anyway, yeah. So again, hopefully that gives you a good overview of materiality. If it's material, it goes in the PPM. If it's not material, well, it doesn't need to go in, right? And so most lawyers are going to err on the side of, hey, we should probably put it in. just to be on the safe side, right? But again, we like to take a pragmatic approach as well. I'll give you an example. We had a client who came to us and said, "Hey, look, I've got this other securities attorney that's saying that, hey, I had this securities infraction, right, in the past, and I know I've got to disclose that, but this securities attorney drafted a disclosure statement that was like 3 pages long. Essentially, they just took the entire, order that and this person had settled the case without admitting or denying the facts that the regulator were asserting. And so they say, hey, look, we're neither going to admit nor deny this, but we're going to go ahead and settle it, right? But their securities attorney wanted to basically attach the entire thing, entire complaint. I mean, it was still a summary, but it's like went on for 3 or 4 pages, made the guy look terrible, right? And it's like, well, wait a second, I don't have to disclose, I don't have to attach all this details, like the fact that, oh, I had this DUI, I don't have to and here's the night of the night of September 7th, 2001, the CEO was driving down the road and went off and drinking. I don't have to tell a big story. I don't have to. Again, we don't have to just put big stars around it and put arrows to it and point it out. Make it a big book, right? No, you just have a very simple, matter-of-fact disclosure. This is the facts, and then, hey, if the investor wants to dive a little deeper, great. We can have a conversation about it. Of the night of September 7th. Of what happened. Let me explain what happened, but I don't have to drive a whole book about it. But that's an example of where sometimes disclosure can I think go overboard, right? I mean, over the top, not really looking at helping the client at all. I mean, honestly, it was maybe hurting them. But so it's again, it's a balance, right? So you definitely want to make sure you disclose it, but certainly you need to do it in a reasonable way, right? So. Anyway, but yeah, thank you for attending this session. For those of you who are members of the forum, we appreciate your joining us, and we definitely are excited about our new capital partners, Marquee Capital. They are an international group of investor. They're a capital source group that. They've got connections with over 30,000 investors, different types of investors, right? Depends on what kind of investors you're looking for. Obviously, it depends on your industry, blah, blah, blah. But they are a super great resource at a very reasonable, and they pay a very, they charge a very, we don't make anything off of it, but they charge a separate success fee. I mean, they charge just an introductory fee, right? And that's they act as finders that way. They're not licensed broker dealers, so you have to be mindful of that. They may not be able to help you with a registered offering or something like that. But certainly, as far as making introductions to capital sources in a private placement context, there's certainly a great resource for that, especially if you're looking for accredited investors or high net worth. Family offices, those kind of investors. That's what their go-to, right? So anyway, happy to introduce you to those folks. And again, they operate around the world. They have about a third of their investors are in the United States, another third are in Asia, and then they've got a fair number of European investors as well. So happy to set up an appointment with them. Obviously, they're going to want to see a fully baked private placement memorandum in place before they make those introductions. But obviously, Mangum and Associates, the securities law firm of which I'm a managing partner, can certainly help you. Or you can, again, feel free to go with whatever law firm you want. But of course, I'm a little biased, right? Anyway, thank you very much. We appreciate all the enthusiasm we've received from existing clients and other people that we just know on YouTube. a lot of people that are subscribing to my free content, I put out free content on YouTube quite a bit. If you haven't checked that out, I think it's just under, I think, Darin Mangum or PPM attorney. Either way, you find me on YouTube, and that really just kind of skims the surface on a lot of these topics. If if you want just a quick overview of something, usually those videos are like 5 minutes, 10 minutes tops. But here in the forum, obviously we do a deeper dive on all these topics. And so anyway, thank you very much for attending, and we will see you on the next forum. Thank you.